Let's talk about LLC. Let's talk about corporate debt, and let's talk about personal liability. I mean, there are some cases where you might be personally liable for LLC or corporate debt. So here are the general considerations. When we talk about being personally liable for LLC or corporate debt, it's important to really understand what corporate liability really means. Okay, so let me give you an overview of corporate limited liability. So when you form a corporation or an LLC, it becomes a separate legal entity apart from its owner. So apart from you, this means what? It means that the business itself can own assets, enter into contracts, and is liable for its own debt. That's why part of the business operations, you want to build business credit so that you can enter into contracts as a business. Okay, so if the corporation or LLC cannot pay its debts, creditors can normally only go after the assets owned by the company and not the personal assets of the owners. However, the business owner can also be held responsible for corporate or LLC debt in certain situations. And into this conversation, I want to discuss how this can happen. Okay, so it's important to really understand that you got to really constantly try to protect your assets, either personal assets or business assets, and even both. Okay, the bottom line here is that you have to really start by incorporating. You got to have a business. You got to have a legit business. I'm not talking about just saying, you know what, I wish I have a business. I'm the CEO of blah, 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 but nobody knows your business's name when they look at the database at your state level. So basically a very easy way to know if you have a legit business, if your business is listed in your state secretary of state's office. In other words, every state has an office that really is the repository for businesses. So your name, your business's name should be in that database. So if I contact your state's secretary of a state office, they have to say, okay, yeah, this company is listed, and the company has actually to be, it has the company must be in good standing. So there's something called a certificate of good standing. So it's not just about being listed. You got to be in good standing, because if you were listed like 5 years ago, but you're no longer in good standing, that doesn't really amount to anything. Okay, so it's important. You have to be legally registered. Another thing here is that when we talk about there are scenarios where you could be personally liable for LLC or corporate debt, and the first one is co-signing or personally guaranteeing business debt. That's why a lot of entrepreneurs, they don't like to have PG when it comes to business loans, and people are flocking to towards no PG business loans, no personal guarantee business lines of credit, no personal guarantee business loans, because you do not want to attach yourself. Okay, if you happen to co-sign on a business loan, you are as equally responsible as the corporation or LLC to pay it back. This is usually the simplest way to voluntarily make yourself liable for your company's debts. And similarly, if you personally guarantee an obligation of the corporation or LLC, then the creditor can come after your personal assets if the business defaults on the loan. That's why a lot of banks, a lot of credit unions, a lot of financial institutions in general, they want the owner, they want the entrepreneur to personally guarantee a debt. This is for them the highest level of protection in case of default. So that the first scenario where you might be personally liable for LLC or corporate debt is if you co-sign or personally guarantee business debt. The second scenario is if you pledge your property as collateral. Very important. Let me break it down for you. When we talk about property, we're speaking about your assets. When somebody were to look at your balance sheet, your personal balance sheet, items that you listed in your assets section, those are property. So because property can be a house, of course, property can be equipment, property can be machinery, property can be a car, property can be anything. It can be land, what have you. So if you have a new company or your company does not have many assets, a creditor may require you to provide some sort of collateral before approving a loan. And if you agree to pledge your house or other personal assets as collateral for the business loan, the creditor may be able to take your property and sell it to satisfy the obligation of the company. So be very careful before pledging anything. Another way where you might be personally liable for LLC or corporate debt is through fraud. This is very important, and I want you to listen carefully here. So basically, a corporation or LLC's owners may also be held personally liable if they are found to have committed fraud, right? If the owner made fraudulent representations or omissions when applying for a business loan, he or she can be held personally responsible for the resulting harm to the creditor and risk losing personal assets. So what happens here is that it doesn't matter if you have been found to have committed fraud, you are liable. Alternatively, if a corporation or LLC was created to further a fraudulent cause or business, a course can actually pierce the corporate veil to get to the owners as well. So this is important when we talk about an LLC or corporation being a shield. There are cases where that shield can disappear. And the shield can disappear as fast as possible. The bottom line here is that a court will very gladly agree to pierce the corporate veil to make sure that lenders, creditors in general, are getting their share, that at least they can be compensated. That's why you have to be really careful. Now, when we talk about fraud, we are speaking about direct but also indirect fraud. So if a court has found you to be indirectly linked to a fraudulent scheme, you could be held liable too. This is why it's really important, if you're a business owner, to actually cultivate the right type of relationships, because otherwise you can be you can be collateral damage, so to speak, quote unquote. You can be collateral damage if you have been found to be indirectly linked to a fraudulent scheme. One thing I also want to say here is that when we talk about fraud, it doesn't matter the state you are in. It doesn't matter. You can be in New York. If you have been found to have been linked to a fraudulent scheme in Georgia or Oregon or Louisiana, you are held liable. This is not. It's not about geography anymore, because courts have said in the past that fraud actually a fraudulent case will apply to the whole nation, so all the 50 states, even internationally, by the way, even internationally. Let's talk about piercing the corporate veil. I actually used that phrase before, and this is an important element to keep in mind. So let me break it down for you. So there are ways, I just share with you the ways you can voluntarily make yourself personally liable for a corporate or LLC debt. However, a creditor can also try to go after your personal assets by eliminating the limited liability protection provided by the corporation or LLC. This is commonly referred to as piercing the corporate veil. Remember that phrase, piercing the corporate veil. So what happens here is that customarily, the corporate veil is usually pierced if the creditor can show that the corporation or LLC was a shell created only to provide liability protection for its owners, or the company was practically inseparable from or an alter ego of its owners. Okay, and this is really important. This is why we've said this on this show and other on this video, but also not on this video, on this show rather, to always separate. You always have to segregate your personal affairs from your business's affairs. That means you got to have a business bank account, a business savings account, a business checking account, a business credit card, so that you can actually charge business only transaction on that card. You do not want to mix up personal transactions with business transactions. And courts will be more likely to pierce the corporate veil if corporate formalities such as holding annual meetings and keeping minutes were not followed. If certain owners exerted too much control over the corporation or LLC, if owners commingled personal funds with the company funds or used personal funds to satisfy company obligations. Remember what I just told you? If you're mixing accounts, that is really problematic, and you do not want to you do not want to do that. And courts will be more likely to pierce the corporate veil if the company was not sufficiently capitalized when it was formed. In other words, you got to ask yourself, are we having a company or what, right? If we're having a company for real, then we need to capitalize the company sufficiently so that if an independent observer were to look at it, they'll see, yeah, this is indeed a company, you know. Let me give you a few extra infos here. When we talk about piercing the corporate veil, it's important to understand that you have to always cover yourself. You have to always cover your back, because the whole thing is that in this tough economic times, many small business owners are scrambling to keep their companies afloat or are closing down, especially in a post-COVID environment, right? COVID happened and a lot of stuff happened. A lot of companies filed for bankruptcy and so on and so forth. And so the thing is that when cash is tight and owners are not careful, if an unpaid creditor sues for payment, a court might say, you know what? I think we want to lift the corporation or LLC veil of limited liability and hold the owners personally liable for their company's business debt, right? And it's one of those things where you got to ask yourself, how do you actually protect yourself? Now, the way you want to do this is that, first of all, I told you before, you have to really understand that there are instances where you can have corporate liability for business debt. And that's what you want. You want the corporation to be liable for business debt. You do not want to be personally liable for business debt. And the way you do this is by actually having a real company, by having an office, by having an address, by having a Google My Business profile, by having a business bank account, by having a business credit card when possible. Actually, if you can't qualify because you have a poor credit, you can still qualify for a secured business credit card. So, and that way, you're able to build credit in the business name, and that's what you want. Because when you reach out to net 30 vendors and you want to build business credit, they will check your paydebt score, they will check your Experian business score, they will check your Equifax business score and see where it's at. And your paydebt score, you gotta have at least 80 to actually qualify. I mean, not qualify, but you gotta have at least 80 so that a lender can consider you as responsible credit holder. So bottom line is, if you want to have a corporate liability for business debt, then you have to actually run the company as a business. You got to run the company as a business. You got to sign contracts under the business's behalf, not under your own behalf. Okay. Of course, there could be cases where you might actually personally guarantee a debt, but shouldn't go beyond that. Now, there are some effects of piercing the corporate veil. It's important to really understand that you are actually you are responsible for certain things. And so if a court pierces a company's corporate veil, the owners, shareholders, or members of a corporation or LLC can be held personally liable for corporate debts. So this means what? A creditor can go after the owner's home, bank accounts, investments, and other assets to satisfy the corporate debt. But courts will impose personal liability only on those individuals who are responsible for the corporation or LLC's wrongful or fraudulent actions. They won't hold innocent parties personally responsible for a company's debts. Okay, and so when court will pierce the corporate veil, there are a lot of things that happen. Basically, if the company's creditors suffered an unjust cost, they could actually pierce the corporate veil. If the company's actions were wrongful or fraudulent, of course, if there's no real separation between the company and its no owners, I think I said this before, yes. So one thing I want to say here is that if someone who did business with the company is left with unpaid bills or an unpaid court judgment and the above factors are present, a court will try to correct this unfairness by piercing the veil, okay? And it's one of those things where you have to, again, make sure that you follow corporate formalities. You have to really you got to hold annual meetings, for instance. You got to keep accurate, detailed records. Those are called minutes, and you got to have them. You got to have them, and because the judge will ask you to show him or show her actually those minutes. If you can show them, then you're safe. But if you can't, that means that you were not running actually a company in the first place. You also want to adopt company bylaws. You want to have company bylaws so that everybody knows that what's happening, everything is clear from the get-go. And you also want to make sure that officers and agents abide by those bylaws. I mean, you can't just adopt company bylaws that nobody follows, right? I mean, the whole idea of bylaws is to actually is for people to actually follow the laws. I mean, they're called laws for a reason, quote unquote laws. Those are the company laws. That's why they're called bylaws. But the thing, if people don't follow them, then you can't really enforce them. then the judge is not going to enforce them either. So if you want to not be held personally liable for LLC or corporate debts, you want to comply with formal rules for forming and maintaining a corporation or LLC. In other words, you want to file officially with your Secretary of State. You want to file paperwork with that authority. You want to send. You want to be in good standing. You need to have a certificate of good standing. You got to have a registered agent. So basically, you have to comply with all the rules and regulations. You have to pay your taxes, including payroll taxes. If you employ others, if you let's say if you hire folks, you got to have an EIN. You also have to maintain a separate bank account for the corporation or LLC. Again, all banks offer business bank accounts. Not all banks, but most banks. You want to never commingle personal assets with those of the corporation or LLC. That way you can protect your ass, right? And don't divert corporate or LLC assets for personal use. This is a red flag. If you do this, this is a red flag and the judge will never forgive you. And one thing that's very important here is that you need to make a reasonable initial investment in the corporation or LLC because you want to have an adequately capitalized company, okay? And one thing you want to also make sure that you have is PG. The PG, the personal guarantee, don't do it. Do not do it. If you personally guarantee a loan or line of credit, you are liable. You do not want to have that. And don't use the corporation or LLC to engage in illegal, fraudulent, or reckless acts, because the court will never forgive you for that. Sorry. So this is really important, okay? And one thing I want to say also is that make sure the world knows it is dealing with a corporation or LLC by openly identifying the company status. So, for instance, it can be LLC on the business cards, letters, quotes, invoices, statements, directory listings, advertisements, and all other forms of company communication. This is really important if you want to really make conspicuous that they're dealing with a company. And when signing company documents, clearly state your representative capacity, such as Jane Doe, President, Acme LLC, John Doe, Vice President, Acme LLC, right? So that everybody knows you are acting not under your own name, but you're acting under the business name. And that's how you are going to shield yourself from corporate liability. Okay, very important. So what's the bottom line here? To this conversation, we talk about when you might be personally liable for LLC or corporate debt. I give you the general considerations, the extra infos, the measures, and now the bottom line. Thank you so much. God bless you. I'll see you next time. Until then, remember, stay marvelous.